On December 7, 1683, a man climbed the scaffold at Tower Hill and was expected to make a speech. Condemned men make speeches. It was the last thing the law allowed them. Algernon Sidney told the sheriffs that he had made his peace with God and that he had not come here to talk, but to die. Then he put a paper into the sheriff's hand and another into a friend's, said one prayer about the length of grace, and laid down his neck. They killed him over a manuscript. His last act was to hand somebody a piece of writing. I am Jeff Kellick, and this is the Consequential Actions Podcast. This is the interview episode for week 10 of our series, Self-Evident, The Road to 1776. This week, we've been on Algernon Sidney and John Locke, the Martyr and the Philosopher. Today, I sit down with Dr. Thomas Laehn, who taught these texts to undergraduates for a living before he ever charged anyone with anything. The conversation is the capstone of the week. This past Sunday, we published the piece on our website. On Saturday, we told the history of the Martyr and the Philosopher. We told the story of Algernon Sidney and his discourses on government, how his manuscript was seized by the government and that was used as a witness against him. We told the story of John Locke and his flee to the Dutch Republic, where he wrote his first and second treatise on government, writings that would be incorporated into the Declaration of Independence itself. On Tuesday, we brought the contemporary application to bear, and we talked about freedoms of thought and freedoms to print and to write and to speak, even when they may be against the government standards. We talked about how that applies in the United Kingdom, and we talked about how that applies in the U.S. as well as China. And we saw the trends that are occurring. Some bad, but some good. And now on Thursday, we close the week with a living voice. What Dr. Laehn adds is a perspective on Locke, explained by a man who taught him and then applied by a man who works inside the machinery those arguments built. There's two threads within this interview. The first is property, where it comes from on Locke's account, and what follows for what a government may do. He gives the way he would have given it to a room of undergraduates, and that is why I asked him. The second is a question Saturday ended on and Tuesday could not close. When a government exceeds the power its people could have handed it, who decides? He has an answer. It involves 12 people in a box, and it's a startling thing to hear from a prosecutor. Now, here's my conversation with Dr. Thomas Laehn. Let us begin.
Welcome to the Consequential Actions Podcast. Here we ask a simple question of the history and the actions that have shaped our lives.
Did this leave us more free or more governed? Because what we do not know can be used to govern us.
And what we choose to ignore always will.
Today, my guest is Thomas Laehn. He's the county attorney in Greene County, Iowa, first elected in 2018, and the first Libertarian ever elected to a partisan office in the state. He was reelected again in 2022. And interesting, before he was a prosecutor, he was a university professor who taught con law and political philosophy at McNeese State. And Thomas has a book forthcoming on Western constitutionalism. He's on the ballot this November for the United States Senate seat that is being left behind by Joni Ernst. And you're running on restoring the balance of powers, ending eminent domain abuse, and you are pledging to serve a single term. Dr. Laehn, Thomas, you put it this way. You swore an oath to defend the Constitution when you took office as county attorney. You believe the system has been corrupted by both major parties. And you date the corruption back to the Truman era, when we went into Korea without a congressional declaration of war. So I'd love to talk with you about all of those things today as we get into our history lesson, talk about what's happening today in Iowa. I should also mention, I know you have two small children, and that I'm sure that is part of your design and vision for why you want to help the people of Iowa, is to help them as well grow up in a free and prosperous society. So thank you for joining us on the show.
Yeah, Jeff, thank you for having me.
Wonderful. So a couple of things to start off with. I wanted to get somewhere other than the campaign at the beginning. We talk about the history of liberty. You and I are both strong advocates for liberty in general, but there's something unusual that I want to discuss. And I do want to talk about current events. We'll get into the pipeline. We'll get into a couple of other things. But we've spent 10 weeks tracing where the ideas of liberty have come to the United States. And this week we're on Algernon, Sidney. We're on John Locke. We are talking about property rights. We are talking about what it means to write in private. And every guest we've had on the show brings something different to the project. You are the first one that we've had that has taught the text to undergraduates. You studied at Drake, at LSU, at the Hebrew University of Jerusalem, and then you taught constitutional law and political philosophy at McNeese State. So, but then curiously, you went to Iowa and became a prosecutor. So that's not the ordinary next step for a political philosopher. So help us understand, how did that happen? How did you get into becoming a prosecutor?
That's a great question. There's some just kind of personal, practical reasons, and then I guess there are some more philosophical reasons. But really, I wanted to get back to rural Iowa. I grew up in a small town called Allison, Iowa, population 1,000 people, in a very rural county here in Iowa. When I was a professor teaching political science, political philosophy, and constitutional law, I was unmarried. I was single, a bachelor, but I knew at some point in my life I wanted to get back to Iowa and to raise my future children in a small town like the one I grew up in Allison. So I thought law school would be a good pathway back to rural Iowa. Every year there are more students graduating from law school than there are jobs available for lawyers. So it's not a good time, not an auspicious time to go to law school. But that national surplus of lawyers hides a lot of variation at the local level. And in rural parts of the United States, there's actually a desperate shortage of attorneys. So I was very confident that if I went to law school, there would be a job available for me in rural Iowa. And so that was kind of a personal reason for going to law school. It was a good path back to Iowa. But also, philosophy is, in some sense, very destructive. Right? The practice of philosophy from Socrates on consists in the exploration of the assumptions upon which people are basing their beliefs and actions. And you're calling their assumptions, oftentimes their implicit assumptions, into question. And this method of doing philosophy is, of course, what got Socrates killed. I believe that in the Western, especially the Anglo-American constitutional tradition, we've struck the right balance between law and philosophy. That, for instance, when you mentioned my forthcoming book, the fifth article of the Constitution has an amendment process. So we're not bound to the Constitution as some sort of eternal document with eternal truths. They're subject to revision, but it's very, very hard to do so. We're trying to balance the idea that we have some grasp of the truth, we have some fundamental commitments, but they are subject to questioning and revision. And I think you need both law and philosophy. You need both that questioning search for truth, which is the practice of philosophy, with institutions and due process procedural rights, processes in place that ensure that the search for truth doesn't result in the destruction of society. And so there was also this kind of philosophical desire to understand both sides of that coin, both philosophy and law, which I think neither can exist in isolation from the other in a way that would make society a place desirable to live in, right? If we didn't have law and order, it would be chaos, as well. People like Locke and Hobbes taught, like, you need law and order. On the other hand, you don't want law and order to turn into, Nazi Germany or the Soviet Union. You need freedom. Because I believe, Cicero said that what makes us human is our ability to question and to search for truth. And that means that the political order can't be beyond question. There must be a balance. So I found the enterprise of law as a transgenerational project, something that I wanted to understand better. And so going to law school also kind of furthered those intellectual interests.
That's very interesting. I want to ask because you brought it up, and I'm just curious. I've been talking a little bit with some others, not on this show, but an Article 5 convention is discussed quite frequently when it comes to how do we deal with the problems with our government today, and that may be an option for us. I think 28 states right now have kind of moved forward on the process for an Article 5 convention. Do you see that as something that's realistic in our lifetime, as something that could be possibly be enacted?
It's definitely possible. I don't think the time is right for a convention. I think that our federal government has become so intrusive, into this security state, but also a nanny state, that I think we really need to work on raising public awareness, restoring kind of active participation in our Republican system of government. Before a convention would be an appropriate method of constitutional change. To be very blunt, I would fear what would come out of a convention if it were held today.
Yeah, I agree. I think you're spot on with that. I think there needs a lot more education, a lot more. There's a lot more effort that can be put into our existing system to try and affect change that I think most of the citizens are looking for, whether they realize that or not at this point.
And I think
great.
I think one of the real issues, and this may come up later in our discussion, but the Supreme Court has asserted itself as the final arbiter of constitutional meaning, such that is taken away from the public square and even from Congress the right to engage in what our Constitution means. That we've just ceded this to the Supreme Court, and I think that has done a lot of damage. That the average American believes that the Supreme Court gets the last word on constitutional meaning. I reject that premise, because if it were true, then the words of the Constitution become empty vessels into which the 5 of the 9 justices on the court can pour whatever meaning they wish. And then we've lost the rule of law. So if this doctrine of judicial supremacy, that the Supreme Court gets the last word on the Constitution, if that's true, then the rule of law has disappeared and we've returned to the rule of men.
I couldn't agree with you more. I think that's a fantastic point that we were talking about there. Let me ask you, you mentioned your book's coming out. Where are people going to be able to find that? Do you have a timeline for that book, for that release?
Yeah, so I believe it's going to be released sometime in 2027. There were some delays. My publishing company that I used for my last book was actually bought out by Bloomsbury. So Bloomsbury will be publishing my forthcoming book, but because of that acquisition, it slowed things down. We had to go back through the review process. So I've been given a final list of edits that my editor wants me to do. Of course, I'm running for the Senate. I'm a full-time prosecutor. I have 2 kids at home. So I'm hoping to get those edits done by the end of this calendar year, and hopefully the book will hit the press sometime in the spring. It would be available on Amazon. Bloomsbury is a major press, so it'll be widely available.
Great. We'll look forward to that. As part of this show, I want to, if you don't mind, I'll put you back in the classroom for a minute. This past week, we've been talking about Locke, and in the second treatise, Locke starts where Filmer said no one was permitted to start, with human beings as they are before any government exists. He says a man has a property in his own person that nobody has a right to but himself, and that because he owns the labor of his own body, when he applies that labor to something given to humankind in common, and we can kind of talk about what that means, he joins something of himself to it, and then that becomes his. And then the political conclusion comes from that property is not a grant from the sovereign, no, that the sovereign may therefore revoke. Give it to us as you would have given your students, as you talk to other people about understanding what property is and why that's so important. And And remember, we do have a lot of newfound socialists out there in the marketplace, so maybe we can help them a little bit too.
Yeah, no, anyone who's studied history or philosophy or economics should know that socialism is a very bad idea. So my approach, so I might even speak a little more freely than I would in the classroom. I believe that every human being has dignity as an individual. And ultimately, end of the day, I believe this is almost more of a theological commitment than a philosophical one, but that every human being has inherent dignity. A religious person might say created in the image and likeness of God. And I believe that. And I believe that when we talk about rights, what we really are talking about are the limits we place on government, beyond which government may not transgress without violating that inherent dignity of the individual. And I think, that's really what's going on in Locke and in the Western philosophical tradition. I don't think we can disentangle theology from philosophy and from political philosophy in particular. But we begin with the premise, whether one grounds it in theology or not, we begin with the premise that every individual has certain inherent natural rights. I would just mention as a side, even in our Declaration of Independence, we had to kind of couch this in theological terms, that we're created equal, we're endowed by our Creator. So I think we reach kind of the limits of reason, but we have to have some fundamental commitment to the dignity of the individual. Whether someone can come up with that rationally, like maybe an Immanuel Kant can come up with some conception of the individual as having inherent dignity without explicitly or even implicitly grounding it in theology, or it's rooted in a faith tradition, whatever it might be. But that's the fundamental choice, I think, is, do we believe that the individual has dignity such that he cannot be sacrificed for the good of society? Or is society somehow superior to the individual, such that the individual can or even should be sacrificed for the good of the community? And that's, I think that's the fundamental question. And Locke clearly comes down on the side of the individual, as does the Western tradition, with the exception of the socialists and the communists, all of the kind of radical movements. So Locke begins with a conception of the individual in the state of nature. Now, this may surprise you, like Filmer has actually got a lot of strong arguments on his side. Right. I wasn't born into a state of nature. No one ever has been born into a state of nature. And I think there's an argument that, Filmer maybe has the better argument as to what a state of nature would look like. Because I was born to my parents, who certainly for the first, few years, 10 years, 20 years of my life had authority over me. So, but Locke doesn't start there. Locke starts with this kind of imaginary place we call the state of nature before government, where we're all, he says, we're all free, we're all equal, we all have these inherent rights. And then you reason from that state of nature, this conception of the world before government, what would people in that state of nature do? And he's not doing history. He's not doing anything, related to chronology. This is a thought experiment. And I think the best way to think about it is the same way scientists come up with scientific models. According to a scientific model, if I drop a bowling ball and a feather in a vacuum, they're going to fall at the same rate. They're going to hit the ground at the same time. So you kind of abstract out of concrete reality. You abstract out of the fact that I was born to my parents and subject to their authority, because you're trying to isolate the crucial aspects of reality that matter most in the development of your scientific model, the aspects of reality that are relevant to the questions you're asking. And so Locke abstracts out of concrete human experience. There never was a state of nature. He never said there was a state of nature, but he's trying to isolate those features of human existence that are relevant to the question of why government exists, and what are the limits of government action, and when do we have the right to rebel against our government? Those are the questions to which he's seeking answers. And so he identifies those aspects of human existence that we're free, we're equal, we're endowed with inherent rights. He thinks those are the relevant aspects of our existence that we should be taking into account when we develop a model of politics or when we develop a science of politics. And as I'm sure you know, and you've probably discussed with your viewers, the state of nature, we're free, we're equal, we have property, as you said, by nature. If I invest my labor into an undertaking, if I mix my labor with the material environment around me, I have a property right in the fruits of my labor. The problem is, without government, the guy who lives down the forest path from me may be stronger than me and can take my apples from my apple orchard or steal my cows or whatever it might be. And Locke identifies three problems in the state of nature: that there's not necessarily an agreement about what our natural rights are. Even if there's some agreement, there's no neutral judge to adjudicate disputes between us. And thirdly, even if there were a neutral judge, if the neutral judge rules in my favor, my neighbor who's bigger and stronger than me might just disregard the judge's ruling. There's no enforcement mechanism in a state of nature. And so we develop, and this is crucial, I mean, this is the most important point of all. We create government to protect our pre-existing natural rights, right? We don't owe our rights to the government, right? On the contrary, government owes its existence to us, and we create government to protect our inherent natural rights, or what I would, if I were writing the second treatise, I would say we create government to protect our inherent dignity as individuals and establish boundaries beyond which the government may not cross. And of course, if they do, if government acts contrary to the purpose for which it was created, then we have the right, we reserve the right to overthrow that government and to create a new government that will fulfill the ends for which it is created. And everything I've said is reduced into a nice summary in a nutshell in the opening lines of our Declaration of Independence.
Yeah, I agree, and I want to address, I want to get into a couple of those things, but I want to address at the outset there are detractors of Locke, and they will point to his ties to slavery at the time, his administration of the Carolina charters. But one of the things that Locke does say, and on this show, oftentimes we find faults with the men, but that does not detract from the points, from the lessons, from the philosophy. The philosophy can be strong on its own, regardless if the man is fallible. And so that's always a premise, whether we're talking about Aristotle, whether we're talking about Locke, whomever we're talking about at the time. One of the things that Locke said in speaking to human dignity, he talked about that ultimately human beings are the workmanship of their maker. So a man owns himself as a steward rather than the absolute proprietor, meaning that under this theory, he cannot put himself into ultimate servitude or slavery because he does not own himself in that way. He is a steward of his property to the maker. So that obviously contradicts with some of the things that maybe Locke was accused of. He had some shares, and we talked about this on the historical episode. He had some shares in the Royal African Company, and the history is kind of unclear about whether that was a grant or a trade from something else. But regardless, his comments were used quite often in the abolitionist movement, and people took these thoughts of that you cannot put yourself into slavery, that you are independent, that you do own yourself. Do I have that right? Do I have that answer to that rebuttal back to people that want to degrade Locke?
I think you do. I mean, what are called ad hominem arguments are a logical fallacy. When you attack the character of the speaker rather than the strength or cogency of his arguments, and that is a logical fallacy. Like, it might be rhetorically effective, but it's not logically sound to challenge a person's character in order to refute the strength of their arguments. And the only exception to that would be, it might be more persuasive if a person's arguments furthered their interests, right? So you might question someone's motives if, we do this in the law. There's an ancient legal maxim, cui bono, who benefits, right? You kind of if you want to know who's telling the truth and who's lying, you ask, well, who would benefit if they were lying? Or who would benefit from this theft or this murder? That gives you a list of suspects, right? So if Locke's arguments furthered his interests, you might then say, well, maybe I should be suspicious of his arguments. But you're saying precisely the opposite, which is there might be inconsistencies between his practice and his speech. And the fact that his own arguments may refute or challenge some of his practices maybe strengthens his arguments because they weren't in his interest to advance them.
Yeah, that's absolutely right. I think that's a tremendous point in rebuttal to those arguments. Now, Locke on property is, and one of the things we often do here is we bring this back to the current state. Where are we looking today? How can we apply the lessons that we learned? And Locke on property is not an abstraction in your state this year. There's a company proposing to move, and correct me if I'm wrong on the details here, but I believe this is what the proposal is. They're moving, I think, liquefied carbon dioxide across Iowa, and the state has vested that private company with the power of eminent domain. And there are families along that route who have worked the land and declined to sell to an easement, or declined to sell their property in an easement. I want to get the posture right before we discuss it. And I want it from you rather than from me, because you're the lawyer. I'm not the lawyer. As I understand, the Utilities Commission issued conditional conditional permits in June of 2024. That permit has been in judicial review in Polk County since, and the court sent it back to the commission after South Dakota banned eminent domain for these pipelines. Is that right?
That's right.
And then the commission issued a new order on the remand at the end of June, and the case is back in front of the court with a request for a stay that has not been ruled on. So tell me where this stands now. Correct anything that I've got wrong, and what do you do? And kind of in your position, where do you stand on this issue?
Yeah, so I'm absolutely against this pipeline, and to give a little bit of context, and then I'll answer your question more directly. So this is all rooted in the federal tax code. Sections 45Q and 45Z of the IRS tax code provides that if you capture carbon dioxide that would otherwise be released into the atmosphere, the federal government will pay you $85 per metric ton of carbon dioxide you capture, and the legal term is sequester, that you bury underground somewhere. And a very wealthy, well-connected businessman named Bruce Rastetter hatched this scheme to capture the carbon dioxide that would otherwise be emitted from our state's ethanol plants, liquefy it under immense pressure, and pipe it across the state. There'd be this network of pipelines connecting all the ethanol plants, and then pipe it across the state through South Dakota into North Dakota, where there's these natural underground caves where this liquefied carbon dioxide could be pumped and stored and permanently sequestered. Now, this project is problematic for two reasons. The first of which is meant to stop global warming or reduce global warming, help the environment. The irony is that all the environmentalist groups in Iowa are against it because it will do more harm to the environment building the pipeline than it will do good capturing carbon dioxide. So those who have looked at the science behind this, like the process of constructing that pipe will emit so much carbon dioxide into the atmosphere and have this scar across the land. That the environmentalists are opposed to it. So the project actually doesn't do any good or doesn't further the end that it's purported to further. What it really does is it makes Bruce Rastetter and his investors billionaires. It's projected that given the amount of carbon dioxide they would capture and sequester, they will literally get billions of dollars from our federal government, direct deposited into their bank accounts. And that's the purpose of the project, to make millionaires, billionaires. That's all the good it does. But then even worse, as you've even worse than this waste of taxpayer dollars, as you've mentioned, our Iowa Utilities Commission vested Summit Carbon, this private company, with the power of eminent domain to take property along the pipeline's proposed route from any landowner who refuses to sell it to Summit Carbon, which is an absolute violation of our property rights, violates the Fifth Amendment takings clause. And then to make matters worse, so the Iowa Utilities Commission consists of 3 individuals hand-picked by the governor. I should mention that Bruce Rastetter has given our governor something around $180,000 in campaign contributions. So she handpicks the 3 members of the Iowa Utilities Commission who granted the permit, as you said, but they included a provision. It was a conditional permit that Summit Carbon had to have a route through South Dakota. Like it had to end up in North Dakota. That was a condition of the permit. And then the South Dakota legislature, listening to their constituents, passed a law prohibiting the use of eminent domain for this project. And so now there was no longer a path through South Dakota to get to North Dakota. So Summit Carbon petitioned to have that condition removed from their permit. And of course, the Iowa Utilities Commission granted that request. So now it doesn't have to go to North Dakota. We don't know where it's going to go. It could go anywhere. But that is where things now stand. There are counties and landowners who have challenged this. The Iowa Utilities Commission removed that condition from the permit, but is still being challenged. The whole project is still being challenged in district court in Polk County. Now, if I can kind of reveal one other aspect of this story. So I had a group of Republican legislators about 2 years ago now approach me, and they asked me if I could draft a bill like what was done in South Dakota that would stop this project in Iowa. And I did. And the reason they asked me was because their own staffers, or they at least feared that their own staffers in the state legislature have been instructed or would be instructed not to write this bill. This is how much control Bruce Rastetter has over our legislative process in Iowa. So they asked me if I could write a bill. I did. It went to the House of Representatives, where a representative there added a lot of language. It passed the House, but what came out of the House was a much bigger bill with many more provisions than my original language, which merely said that you can't use eminent domain for the construction of hazardous liquid pipelines on agricultural land in the state of Iowa. That was it. It passes the House with that added language, passes the Senate, goes to the governor, and she vetoes it. She vetoed this bill that would have protected property rights in Iowa, even though we know from public opinion polling in the state of Iowa that 78% of Iowans, 78% are against this project. So even though the overwhelming majority of Iowans are opposed to the use of eminent domain for the construction of hazardous liquid pipelines, it is clear to me that interest groups and very wealthy, well-connected Republican donors have commandeered our legislative process and are actively obstructing the will of the people.
That's one of the things you said there in talking about the takings clause. So for some of our listeners, the Supreme Court has said that taking is justified if for public use, not private use, for public use with just compensation. And so, one of my questions is going to be kind of where does the court draw that line? But if the legislature is drawing that line and saying we are putting forth this bill, had the governor not vetoed, that would have been a clear instruction for the court. Yeah. If not, how does the court make a determination what is public use when we're talking about a situation like this? Because if you're saying that the Utilities Commission is saying this is public use, where does that come down in the courts?
Yeah, we should all be outraged at our United States Supreme Court. And again, this is why I believe we're not bound by their determination of constitutional meaning, because they're quite frankly wrong sometimes. I mean, and we should all, unless we're prepared to accept Dred Scott or like these, horrible decisions from the past, clearly we, the people, can say, no, you got it wrong. And this is one of them. In Kelo, there's the Kelo decision, where the Supreme Court was faced with the following question. A city, the city of New London in Connecticut, wanted to vest a private development corporation with the power of eminent domain. They wanted to have a revitalization project in their city. They were trying to court a pharmaceutical company to come to the city of New London to build a new headquarters there. They wanted to have some sort of aquarium, a new hotel complex. Like, they wanted this redevelopment plan. The only problem was that the neighborhood where they wanted to build it was filled with people's homes, people who had lived there for decades. And the city of New London vested this private development company with the power of eminent domain, giving the company the power simply to take people's homes against their wishes. The takings clause does require just compensation, so you'd have to pay them, the fair market value for their house. As you can imagine, there's people who say, well, I won't accept fair market value. My kids had their Christmases here, or I got, my wife and I bought this house the day after. There's reasons people shouldn't be forced to sell things they don't want to sell. But the city of New London vested this corporation with the power of eminent domain. And it goes all the way to the U.S. Supreme Court. And the U.S. Supreme Court said that when the takings clause says something must be for a public use, so that's the language in the Fifth Amendment, that the government can only take private property if it's for a public use, which traditionally meant like roads or schools, property actually owned by the government that all members of the public could use. But the Supreme Court gave this expansive interpretation of public use and said it's essentially synonymous with public purpose. That if this project has any public purpose, it's a valid use of eminent domain. And what's especially concerning, so the Supreme Court upheld the power of the city of New London to give this private corporation the power of eminent domain to literally tear down people's homes against their wishes. And the public purpose was that it would increase the tax base, right? So that if you build a new hotel and a headquarters for a pharmaceutical company and an aquarium and whatever else they had in this redevelopment scheme, that you're going to generate more tax revenue for the city than if you allow it to be a residential neighborhood. And that alone was sufficient to satisfy this new public purpose test. Now, if that's true, if that's what the takings clause allows, the Supreme Court has essentially read the takings clause out of the Constitution. Because it means if anybody can use your land better than you can, as determined by the government, you're person A, but the government believes person B can make more productive use of your land than you are, such that you'll generate more tax revenue for the government, then the government can force you to sell your land to person B. And this is exactly what Locke was trying to prevent. This is inconsistent with the foundational commitments of our system of government, that we create government to protect our rights, including, perhaps foremost, our property rights. And now here government is facilitating the violation of our rights.
Yeah.
Right? So,
I mean, you could take that to an ad absurdum and say, I could do more with you than you can do with you. Therefore, I have a right to use your labor, to use you. Yeah.
Yeah. Yep. No, it's totally inconsistent with our nation's foundational commitments. And yet this is where the Supreme Court has come down. And so Summit Carbon, because they can use a farmer's land better than the farmer, that is actually laughable. So their explanation of why it's a public use has actually evolved. So it started out with this kind of global warming, like that's a public purpose, like preventing global warming. But then when like the science actually wouldn't support that, is actually going to do more harm to the environment, they said, well, this is why we're a public use. We're actually like a road because we're only going to fill our pipeline to 90% capacity. And if you want to hook up your garden hose and add your liquefied carbon dioxide to this pipeline, you can. And therefore, we're just like an interstate. You can use it too. That was their justification for why they're a public use. And that is ridiculous. I mean, as only political appointees doing the bidding of millionaire party donors could believe that's a public use.
Yeah, but even if it's not by a select group of individuals, you still have to have, even if it's the majority, you still have to have minority protections.
Yeah,
you still need to have that in there. That's one of the fundamental bases of our form of government, of liberty in general, that we need to continue to stand up and fight for. I thank you so much for going through that. I think that that's very enlightening. We'll continue to follow on with how that evolves over time. I have another question that I wanted to put to you, and it's Locke's remedy when government makes itself arbitrary and seizes property it was established to protect, is that the trust dissolves. And, you know, we certainly, we talked about it in the 1688, 1689 revolution. We talked about it in our declaration in 1776. When you find a long train of abuses trending the same way, then you have the right to act on it. Locke said that. Our founder said that. That's something that's ingrained to us since grade school. But who makes that standard? Who is the umpire? Who looks at that and says, yes, there has been a long train of abuses by our government? Because, again, you could take this in many directions. Almost every aggrieved party throughout politics could say that at some point. So who ends up being that umpire? How do you assess that in modern times?
Yeah, that's a great question. And this is actually a good example of where philosophy and law can interact in very productive ways. And this is actually the primary thesis of my forthcoming book, which is that our founding fathers, I think their greatest contribution to the Western constitutional tradition is that they wanted to find mechanisms to institutionalize, or I could say domesticate, revolutionary warfare, so that we would have the means by which to overthrow our government without needing to resort to our pitchforks and our shotguns, right? And three, I think, very clear examples. The most important of which is actually the amendment process in Article 5, that we could, at any point, we could abolish Congress if we want to, right? Peaceably through a constitutional amendment process. I think we need term limits. I think that would help a great deal for members of Congress, and we could do that. We were the first country in the history of the world that found a means by which we could alter the constitution of the state itself within the constitutional framework that existed. That had never been done before. Article 5 was truly, it had some predecessors in the states. It was actually Pennsylvania that was the first state. Actually, it was when it was chartered. It was the first colony to have an amendment process for its basic framework of government. That's the first time in human history. So this is a distinctly American contribution to Western constitutionalism, that we can amend, alter, or abolish our system of government peaceably through an amendment process. Of course, less radically, elections are ways to fundamentally change the direction of government. And then thirdly, something that I believe in, paradoxically as a prosecutor, is jury nullification. That the jury can refuse to enforce a law that it believes to be unconstitutional. So I think, the arbiters of when the Constitution, or let me rephrase that, the arbiters of when the government is violating our constitutional rights are the people when we act through the amendment process, the people when we vote on election day, and the people when we assemble in the jury box. I'm not a proponent of radical change. I'm philosophically quite conservative. Things like the French Revolution alarm me. I don't call the ultimate check, of course, is the Second Amendment right to bear arms. I mean, we do. I think that's why we have the Second Amendment, is ultimately, if all of those constitutional mechanisms fail, we can resort to the right of self-defense, which ultimately that is what the revolution, the right of revolution is the right to self-defense. But I think our founders hoped that they had provided us with peaceable means by which to have revolutions, revolutions within the constitutional framework itself. And so I think every time a jury assembles, you have 12 jurors in a jury box. They are the people, and they are the arbiters of constitutional meaning. Every time we assemble in the voting booth on election day, we are the arbiters of constitutional meaning. And anytime there's a constitutional amendment and we go to our state ratifying conventions, we are the arbiters of constitutional meaning.
I think that's a fantastic point. And for our listeners that were here last week, we had Brendan Kirby talking about the importance of serving on your jury. We hear it again. We hear so many people finding ways to get out of jury duty, but really it is one of the ultimate forms of applying your liberty and applying it on behalf of your fellow citizens and standing up and listening and learning through the case, being a stranger to the defendant, hearing the prosecution's terms. I know you're a proponent for jurors as a lawyer, as a prosecutor. I think it's so important. I'm glad that we were able to kind of bring that into these last 2 weeks. For anybody that's out there trying to get out of it, serve the duty and take it with honor for what it is.
Yeah, I agree.
One of the other questions kind of I wanted to get into. Oh, I'm sorry. I lost you there for a second.
No, that's quite. I agree. And if the judge tells you that he or she is the ultimate determiner of what the law means, ignore the judge, because that's a pretty standard jury instruction. I always fight to exclude it from the jury instructions we get in Greene County. I don't believe for an instant the judge gets the last word on what the law is. The people get the last word on what the law is. Jury, I would give up every other institution of government before I would give up the jury, because the jury is the ultimate guarantor of our liberties, that you and I cannot be deprived of our liberty unless 12 members of our community agree we've committed the crime and that the crime, the criminal statute is constitutional and is not itself a violation of the Constitution.
Wow, I think that's a great clause at the end, and that's so important. And there's so many people that don't understand about jury nullification. So if this is the first time that you're hearing this, we'll have some links down in the comments, some more things that you can read up on and learn. I think it's very important. And as we just heard, it is the ultimate check on the way that our system is designed and the laws that are put in place. One of the other checks on our system is elections. And you are running for the United States Senate. You are running as a libertarian. You are taking the seat or trying to take the seat that is currently held by Joni Ernst, a Republican. What is it about the Republican Party, the Democrat Party, that needs to be addressed from a third party, whether it's a libertarian or independent? How are we addressing that in our elections? We know that the bulk of our citizens are displeased with the duopoly, with the major parties. Yeah. Is that the reason why you're running as a libertarian? Are you fundamentally a big L libertarian or a little L libertarian? Or where do you fit in that idealism?
Yeah, I mean, I'm a true libertarian vis-a-vis the national government. What I really am at the end of the day is a constitutionalist. I believe in the Constitution and the rule of law, and I swore an oath to defend it. And I believe the Constitution was designed to ensure that our national government was a government of enumerated powers, of limited powers. I believe, and this is said only partly tongue in cheek. Is pretty spot on with what I believe, that my life should only intersect with the federal government on 2 occasions: when I try to cross the border to get into the country and when I go to the post office. Otherwise, by design, the federal government should have no role in my life. Now, I'm not a true libertarian, kind of philosophically or politically, vis-a-vis the state and local governments. I believe under our Constitution, the state governments have the authority, the legal authority, to enact legislation that's anathema to libertarians, like morals legislation. Now, we might disagree that it's good laws or bad laws, but my concern is preserving the constitutional order. And that's why I'm running for federal office, because the level of government that is principally violating our rights is the federal government, the national government. And the third party, Libertarian Party, absolutely, we need a third party to overturn the duopoly and expose what's really happening in Washington, D.C. 22 years ago, I interned in the United States Senate. And I was a young man taken to the floor of the Senate, and there was one senator on the Senate floor talking to the television camera. And I was young and naive and idealistic, and I asked the guy who was giving me the tour, where are all the other senators? And he said, well, you don't understand how it works here in Washington, D.C. They're never all on the Senate floor. They're just taking turns talking to the camera, running for re-election. They're not like speeches directed toward other senators. They're speeches directed to the voters back home to try to get reelected. And I realized then that this was all just one big Hollywood production. Every member of Congress, every single one, Republican and Democrat alike, are complicit in defrauding us. They want us to believe they're on the Senate floor deliberating, lawmaking, when in reality they're off meeting with donors and interest groups and raising money for their next campaigns. All the legislative power in our country, and I say this not as a candidate for the United States Senate, I say this as a former professor of constitutional law and political philosophy. The legislative power in our country has shifted from the Congress to the White House. Law is now being made via executive order, not by laws passed by Congress. And one brief example, and this is why I'm running for the Senate. This is why I'm running as a libertarian. You mentioned at the beginning of the interview, I have 2 small children, and I want them to grow up with the same liberties I enjoyed during the course of my life. And last year, Donald Trump issued an executive order that purported to make it a federal crime to desecrate the flag, to burn the American flag. Now, I think there are good and fine and reasonable people in the United States who think it should be a crime to burn the American flag. There are other equally good and reasonable people who believe that's a form of free expression protected by the First Amendment. I fall in that second camp. That's not the debate I want to have. But let's just set that debate aside. Every American should agree that the president does not have the power to create criminal statutes with the stroke of a pen and throw us in prison. Trump said, if you violate this executive order, you'll go to prison for 1 year. So he is purporting to have the authority to make criminal law via executive order and to deprive us of our liberty, to separate us from our families, separate us from our communities, put us in a federal prison for disobeying him. And if that's the reality of the system of government under which we live, we have lost the republic. We are now living in a dictatorship. And I want to be very clear, Donald Trump is not the problem. He's just the most recent, as you said, since Truman, of presidents leading our country to war without declarations of war. Obama issued hundreds of executive orders. Trump is not the problem. The problem is a Congress that has totally abdicated its constitutional responsibilities.
One of the solutions you talk about for that is congressional term limits. You have talked about that running as a senator, you are looking to serve 1 term. How do you think that actually impacts and makes a fundamental change in the shape of Congress, in the priorities, and in the motivations for the people that are serving?
Yeah, so we know the political science literature has just demonstrated this conclusively, that members of Congress, their principal concern is to be reelected. And I think many of them, maybe most of them, go to Washington, D.C. with the best of intentions. They want to do good. I will assume that they want to do good. The problem is, if you want to do good and to continue doing good, you need to get reelected. So then the goal of reelection becomes what political scientists call the proximate goal, the goal that must be achieved over and over again before all else. And that then shifts their priorities. Well, if you want to get reelected, you now have to raise tens of millions of dollars. And the only way you can raise tens of millions of dollars is if you spend your day not on the Senate floor, but meeting with donors. And if we had term limits, it would at least mitigate that problem, where senators, representatives would not, at least in their final term, let's say senators get 2 terms. I'm not committed to any specific number, but let's say hypothetically we have a constitutional amendment to limit senators to 2 6-year terms. Well, at least then for the years 7 through 12, they're not being motivated by the desire to run for re-election because they can't. Myself, I'm only going to run for 1 term, serve 1 term, because I don't want any Iowan to ever question my motives. If I'm only running for 1 term, I'm only serving 1 term, then every decision I make, the people of Iowa will know that I'm doing it because 1, I believe it's constitutional, and 2, I believe it's in the interest of the people of the state of Iowa. And I will have no ulterior motive because I'm not running for re-election.
Yeah. Yeah, I think that's a solid point. And I'll give, and anytime I have this discussion, I do come back to, and I hate to invoke him, but a comment that Mitch McConnell made when he said that we have term limits. It's called the vote, and people vote. But what we've seen in the statistics and the demographics, 96% of incumbents win re-election, even though 15% of them, it has a 15% approval rating. So there's that struggle there. And ultimately that does come back to us, the voter, to us, the citizens. And it's so important that we do, even if term limits were put in place, we go in as educated voters, and we understand the people that we are voting for, and not just at the federal level. As you said, the state that we're living in, the localities that we're living in, we can set different laws there, and we are beholden to those laws. So it's important we understand who we're voting for at the state level, at the local level, at the county commission level, whomever that we are putting in charge to work with us and protect our rights and the rights of our fellow citizens.
Yes. Yep. Amen. Our republic will only survive if the citizenry stays engaged. And I think actually the federal government is doing its best to not engage us. And to, give us a dichotomous choice every 2 years in these elections. When in reality, we know from a Gallup public opinion poll that 63% of Americans would prefer a third party. So we're the majority, and we need to reject this false narrative that every 2 years we have to choose the lesser evil.
Yeah, that's exactly right. That and for libertarians, whether you're part of the party mechanism, whether you're a small L libertarian just as part of the ideology, whether you're an independent, whether you're somebody out there that's just disaffected by the Republican or the Democratic Party, it is something that you should look at in your community. Again, learn to understand who the candidates are. And by the way, if there is a candidate that you support and you approve of their decisions and they happen to be part of the duopoly, that's fine too. But be educated yourself. Thomas, thank you so much for being with us this week. It's been a wonderful conversation. I do want to point some people to where voters in Iowa, where people that want to donate to your campaign, where can they find you? Where can they learn more about the issues that we didn't get a chance to talk about tonight?
So I have a campaign website. It's Laehn, spelled Laehn, the number 4, Iowa, spelled out IOWA.org, LaehnForIowa.org. I'm on social media, X, Facebook, Instagram. You can find me. We do a lot of our posting, on those social media sites. The website's pretty static. But yeah, you can definitely find me on social media or on my website.
That's great. And we'll have those links below in the comments as well as on the screen right now. So make sure that you get an opportunity to look at the other issues, engage in the conversation. Again, being active on social media is so important right now because you've got a direct line to people that are interested in the vote that's happening, and you're able to give direct feedback. So definitely engage. We look forward to maybe another conversation down the road. We can get into some more topics. It's been wonderful having you this week. Thank you very much.
Yeah, thank you for having me, Jeff. I appreciate it.
Awesome. Welcome back. That was my conversation with Dr. Thomas Laehn, and I want to take a few minutes on what came out of it. First off, Thomas, thank you very much. 10 weeks into this series, the first guest who has taught this material for a living and then spent another hour with us teaching it to our audience. The thing I will keep is what he did with the state of nature. He did not defend it as history. He said Locke was not doing history and never claimed to be. That the state of nature is a model, built the way a scientist builds a model, by stripping away everything that does not bear on the question you are asking. He brought up the metaphor of dropping a bowling ball and a feather in a vacuum, and that they land together as a matter of scientific record. Nobody has ever watched that happen in a field, yet it is still true. And that disposes the common objection, the Fillmore objection to Locke, in about 90 seconds. And then he did give Fillmore his due. He said that Fillmore may well have the better account of the world as we find it, because no one was ever born into a state of nature. Everyone is born to parents who have hold or authority over them for years. That's an interesting concession, and it brings the point together and makes Locke's argument even stronger, I believe. Saturday ended on a question rather than an answer. Tuesday ended by drawing a line and then admitting somebody has to draw it. Dr. Laehn answered both. On the show, we close by asking one question of everything we examine. Did this leave people more free or more governed? He put a live American case in front of us, so let us run through it. Not on the pipeline, which is the fight, and he argued it at length, but let's run on the machinery underneath. Here's the strongest version of the other side: a pipeline, a rail line, a transmission corridor. None of these work piecemeal. A line has to be continuous, which means a single owner who refuses can stop a project that hundreds of neighbors already agreed to. That is not a hypothetical. It is why the taking power for common carriers is older than most of what we argue about. The railroads were built on it. The wires running to your house you grew up in were built on it. And a legislature cannot sit as a routing board, parcel by parcel, across 99 counties. So it hands the judgment to a commission with the technical competence to make it. On its face, there's nothing sinister about any of that. It is what a state does when it needs a decision made by somebody who actually understands the subject. Now, the reply: the objection is not that the commission exists. The objection is the chain. The people delegated authority to a legislature. The legislature delegated the taking power to 3 appointed commissioners. The commissioners vested that power in a private company. At every step, the power moved further and further from anyone a farmer in Iowa can vote against, can hold accountable. And at the end of it, a corporation holds a right that no neighbor of that farmer has ever held and has ever given away. That's the real question. Not whether the taking power exists, but whether this particular version is a power of free people protecting what is already theirs, could have handed over on any terms they would have accepted. The power to take a family's land for a road they may drive on is at least arguable. The power to hand a private company the right to take it, exercised by appointees rather than by a legislature that holds the power, is not that power. It shares a name with it and little else. That is more governed. And then the answer he gave that I want to stay on, because it is the best one I've heard. I asked him who the umpire is. Locke says, a long train of abuses dissolves the trust, and every faction that ever lost an election has been able to describe its grievances in exactly those words. Thomas's answer was great. He said the founders built peaceable revolutions into the system so that the question would not have to be settled by force. The amendment process, Article 5, is where a people can alter the framework from inside the framework. And it's a uniquely American construct. He also discussed the ballot, and he's running for United States Senator to affect change. But then he mentioned the jury box. He said he would surrender every other institution of government before he surrendered the jury. Now, there is a piece of that argument that we did not discuss out loud, and it is a strong piece. A jury nullification only runs one direction. 12 people can refuse to convict a man. They cannot convict one the evidence does not reach. The power is real, and it is one way, which makes it a shield rather than a sword. Now, the part that should keep us honest The jury he would keep above every other institution is the same instrument that killed the man we spent Saturday talking about. Sidney's first act at the bar was to object to the jury because it had been assembled by a sheriff loyal to the crown, and he was right about that. 12 men in a box heard 3 words of Latin from the bench and sent him to Tower Hill. The box protects you when it's filled by strangers who owe the government nothing. It does not protect you when somebody else decides who sits in it. So what stands between those two juries is not the jury, it is everything around it. Who fills the box? Whether the bench may pack it, and whether a man acquitted may simply be tried again until the verdict comes out right. Those are not questions a jury can answer by itself. Those are questions a constitutional settlement answers. And the first serious attempt to answer them in English is 1689. Saturday asked how you would know if you had been judged rightly rather than merely lost an argument. 12 strangers is a better answer than one man's certainty about his own righteousness. It is not a finished answer. Next week, our journey continues with 1688, the glorious revolution, the settlement that placed fresh limits on the crown, and the Bill of Rights of 1689. The triumph and the warning, the history on Saturday, its application on Tuesday, and where we can, another conversation to close the week. Article 11 is already up on Substack if you want to read and prepare for the history that is coming next week. And if you want to know who is on your ballot in November, find out now rather than October. Review the candidates, study them, find out what their positions are, engage with them on social media, and ask them directly. Until then, I want you to also keep asking the only question that matters. Did this leave us more free or more governed? I am Jeff Kellick. This has been Consequential Actions. And until next time, have a great day.